Good evening, everyone. I, CS Pradeep Chandra Joshi, on behalf of the Institute of Company Secretaries of India, extend a very warm welcome to our respected speaker and participants who have gathered with us today for this enlightening session on art of advocacy, pleadings and appearances under the umbrella of EEE 5.0 Master Knowledge Series. Before we delve into this topic, we are delighted to announce that the applications are open for the 7th ICSI Best Secretarial Audit Report Award and the 5th ICSI Best PCS Firm Award. The last date to submit the application is 25th September 2025. Also, we are overwhelmed to announce that the 4th ICSI Board Mentorship Program is to be held from 18th to 21st September in Kalimpong, West Bengal. For further details, please visit the website of the Institute. Now, coming to the topic of the day, the art of advocacy is an effective communication to the canvas of the mind through the artwork of four brushes: effective speaking, effective writing, effective reading, and effective listening. Effective advocacy is not merely about presenting arguments, but about crafting a clear, structured, and persuasive case based on sound legal reasoning, facts, and evidence. Similarly, pleadings form the backbone of advocacy as they establish the foundation of the case by articulating the issues, relief sought, and the legal framework in precise and concise manner. The art of advocacy and pleadings is an essential skill for company secretaries, particularly in their role as governance professionals and legal representatives. Before various regulatory and quasi-judicial forums, for company secretaries, mastery of these skills enhances their ability to represent companies and stakeholders effectively before the appellate tribunals such as National Company Law Tribunal, that is NCLT, Securities Appellate Tribunal, SAT, and other authorities. This webinar will focus on developing the practical aspects of advocacy, including drafting pleadings, framing arguments, court etiquette, presentation skills, and strategies to handle complex matters. It aims to equip the members with the tools of confidently navigate legal proceedings while upholding the principles of professionalism, clarity, and the credibility in their role as trusted advisors and representatives. For detailed deliberation on the topic and to have expert views, we are honored to have with us distinguished expert Dr. K.S. Ravichandran sir, who brings with him deep regulatory insights and practical experience in advocacy and pleadings. It's my proud privilege to read his profile for our members. Dr. K.S. Ravichandran is the founder and managing partner of KSR and Company Secretaries LLP, Coimbatore, Bangalore, and Chennai. He holds a doctorate degree from Department of Management, Alagappa University, on prosecution of directors under the company law and criminal law in India and UK. Currently, a member of the Management Committee of Bangalore Chamber of Industry and Commerce, BCIC, and co-chair of a Sustainability and ESG Committee. His areas of specialization include board process, governance, audits, compliance solution, corporate restructuring, dispute resolution, IPRs, mergers, acquisitions, insolvency and bankruptcy, and arbitration and conciliation. He has appeared before various regulatory authorities and tribunals such as National Company Law Tribunal, National Company Law Appellate Tribunal, Debt Recovery Appellate Tribunal, and Intellectual Property Appellate Tribunal. He was an independent director of the Karur Vaishya Bank for 8 years and he has chaired several board committees. We are privileged to have such an eminent speaker to deliberate on today's topic, and I am confident that today's deliberation will enrich our understanding and equip us with updated knowledge. Once again, I welcome you all and thank you for taking time to join us today. Let's engage, learn, and grow together. Please post your queries and same will be taken up either at the end of the or the during of the session. Over to you, sir.
Yeah, ready? So, good evening, ladies and gentlemen. It is a very interesting topic and when Pradeep was introducing the topic, he was effectively talking about effectiveness. It's a very interesting thing to listen to the various effective things a person has to follow up. There are importantly certain things which are possible only by experience. One is, he was telling about the art of pleadings. Correct? So you remember this 5 P's to buy peace. 1, we should be able to decide who are the parties before us. In a litigation,
Recording in progress.
so the 5 P's, of which number 1 is you should be able to decide who are going to be the parties. And it is always, there are 2 sides minimum. There are 2 sides minimum. Yes, 2 sides to the coin. One is the complaining side. Another is the responding side. When we talk about litigation and company secretaries, we are able to confine to our skills relating to tribunals and appellate tribunals. When I say this, I am not stopping under Companies Act alone. You have to expand your thoughts that beyond Companies Act also, there are several other opportunities where you will be able to practice. Adversarial means litigation, where somebody says, affirms, and somebody denies. Issues created. And in order to create the issue, or in order to see whether there is an issue that has come up, parties are supposed to be 2 sides easily, affirming and denying. Therefore, straight away, the first P, which is very important in our practice, is identifying the parties. With that only, we can start the process. Whenever we discuss about an adversarial litigation nature of cases, for example, to give an interesting, to give an example that all of us will be able to relate and understand. For example, oppression mismanagement cases. Definitely you are going to make allegations against one. There will be counter allegations. So there are parties, petitioners. There are respondents. Petitioners will first start the game. Allegations will be made. And respondents will reply and also make counter allegations. Then you will give another reply to answer those allegations. This is because litigation is of such nature where there are issues that are presented by the court, before the court, considered by the court, and adjudicated. The adjudication is a function of determining the issues and identifying where the truth lies. Unfortunately, we use the word lies, where the truth lies. In every case, when you are filing, you will always know it is a 50-50 chance. You can go this side or that side. The result can go this side or that side. Therefore, parties identifying is very important, because if you have omitted somebody who is in the thick of the issue, a necessary party or proper party which has been omitted is going to be a costly and fatal thing to the litigation itself. Number 2 is choice of forum. when we talk about choice of forum, subject matter of the dispute is very important. For that, somebody should have the understanding capacity. What is the core issue involved? What is the foundation of the case, or what is going to be the foundation of the case? If the foundation of the case is this, whether we have a case before this court or that court, which is the forum available to you to resolve this issue? Is it a civil court? Or is it a matter coming under the Arbitration Conciliation Act? Or should it be by any other special tribunal like NCLT, Securities Appellate Tribunal, Competition Appellate Tribunal? Therefore, subject matter of the or core subject matter, core issue, foundation must be clearly defined by you. The definition clarity is the first step. If you know the subject matter of the dispute or the core or foundation of it, then you will think whether to go to one forum or another. For example, there are matters where you may find better relief will be available in a civil court. For in some cases, better relief will be available in tribunal. To give an example of choice of forum, let us say I advise my client for removing a director of a company. I am a company secretary. I have been in practice for several years. I know the provisions. 1956 Act, I know. 2013 Act, I know. Secretarial Standard, I know. Board meeting, general meeting, सब कुछ मुझे मालूम. So what I'll do? Beautifully, I'll prepare the procedures, provisions, everything I know. Right? I am a specialist in the field of company law. So I have in my hands a complete grip of the provisions and the provision rules, which means I will do the removal of my director directly in terms of the provisions of law. Follow the entire process, procedures thoroughly. Nobody can pinpoint anything. Now, where is the legal issue in this? Is there any illegality? Is there any contravention? Is there any non-compliance? Nothing. Because everything is perfectly followed. Yet, sometimes the person who has been removed may be a shareholder, will feel he is oppressed by the majority shareholders. Because you know, removal of shareholding, removal of directorship requires just 51% voting. Ordinary resolution, unless articles speak otherwise or agreements speak otherwise. So therefore, what happens? There is no illegality. There is no non-compliance. You are not able to say any difficulty. Without difficulty, they are able to present you everything on paper exactly as required under the secretarial standards of our institute. But then you will be winning the case provided you are able to show that this particular cause of action is basically an oppressive action against minority by majority. And therefore, 241, 242 of the Companies Act must be invoked because the NCLT, previously the Company Law Board, is clothed with equitable jurisdiction conferred upon it. Which means they will not look at your non-compliances, perfect compliance, perfect in order with, in accordance with law. Yet, the NCLT alone has powers to declare that the oppressive act of removal, though in compliance of law, though by majority voting, is set aside because it is held to be or found to be or declared to be oppressive. Therefore, this is just a guidance I am trying to give you upfront for the purpose of choice of forum. Each of these cases, we should be able to say, this is the forum where the relief that my client wants will be available. Therefore, when you decide these provisions and procedures, you are going to decide which is the proper court for that, proper forum for that. So choice of forum requires clarity with respect to the definition of the core issue involved in the case, why a person feels aggrieved. And that, if it is defined properly and clearly, then you will be able to bring about a solution to the choice of forum also. Then I will tell you, you want to say anything?
No, sir,
Go,
please,
shall I go on?
please continue, sir.
Yeah. Pleadings. Pradeep was mentioning about pleadings and the importance of it. It is not about oral arguments, it is not about submissions, it is about written nature of it. Pleadings are very important. I am remembering some very age-old case of Supreme Court in a matter of Ram Sarup or something, where pleadings are revealing to the extent required and hiding all the other things. See the language I am using, you should be able to understand. Pleadings are such, they reveal to the extent required and hide everything else. Remember this language. The proposition relating to pleading is the other party should be able to understand what is the case you are making. What case are you making out is what is the requirement of pleadings. When I talk about pleadings, I am not talking about typing about name of parties, court, and all those procedural aspects. Core issue relating to the cause of action, relating to the dispute, relating to the grievance, how you are oppressed, what is the issue involved, all that constitute the core pleadings. Other things are just fitments. Writing names of parties and so many things, the format is there, you need to fill up a lot of things. Those things are, core pleadings are supposed to be communicating to the other side what is your case. So if you are supposed to say it in so many words, please say it. But need not be explaining the whole of your case, but must be revealing as much so that they are able to understand. So revealing as is necessary, hiding everything which is not required. In the writing, I am talking about pleadings. So we have decided about parties. We have decided about proper court. We have decided about procedure, this pleadings. Proper court, when I say, you know that it is basically because of provisions also. Basically, proper court can never be decided without understanding what is the provision operating in that area for that particular subject matter. On the basis of provisions only, you are deciding the proper court. So we have done with parties, proper court, pleadings. Now what is the requirement? Just remember, you are supposed to know the papers and the prayers. Papers are what? Papers are nothing but what is the document or record you are relying on to support your case. In this respect, now itself note down. Every statement of fact must be pleaded and proved. For example, I am a shareholder. I am holding 1/3 of shares in the company. So many number of shares of rupees, so many rupees, etc., etc. From so and so year. Now my shares have been removed. Somebody has come in my name, or somebody's name has been put in my place. Suppose that is the case. This is what you are pleading. This is a statement of fact. Every word in this is a statement of fact. Therefore, facts are nothing but the statement of facts are required to be proved by you through the papers that you are relying upon. Normally, what we will do? We will issue a share certificate. We will show the annual return. We'll show the balance sheet. We'll show the correspondence, meetings of shareholders meetings where you have attended and exercised your voting rights, right? So therefore, every pleading which consists of a statement of fact must be proved by papers. This is a rule. I am giving you technical guidance to the art of advocacy. Now you must remember your pleadings, your papers must be aligned with the prayers you are asking. आखिर क्या चाहिए आपको? What is the relief that you are asking? You should be able to connect it. Therefore, what we do a triple P two-way test. We do a triple P two-way test. Means what? Pleadings, papers, prayers. Just remember this triple P. And two-way, both sides it should work. Go from the prayers and see whether justifying pleadings are there. Whatever you are asking, I want setting aside of transfer of shares. That should be a prayer, let us say. That is called prayer, right? To set aside the transfer of shares made on 18th August 2025. That's your prayer. Sufficiently it should have been pleaded in the pleading part. Prayer say you have to check whether we have pleaded what is this problem. You can't simply bring some prayers which are not supported by pleadings, and pleadings cannot be there without supporting by papers. So हर एक paper के लिए there should have been a pleading, and हर एक pleading के लिए there should have been a prayer, paper, and all these things must be justified by the nature of relief you are asking. If you are not able to do this test, you are going to have difficulties. Triple P test, papers, pleadings, papers and prayers, two-way test is required for every case you do it. Don't ever think that I will rely on my memory. I have done everything. This baएं हाथ का काम है. I have done 100 times. No. Do every time. And last but not the least in this 5P is precedents, judicial precedents. Judicial precedents is an enormous source in your hands to refine your thoughts. It is not that first time this is happening. It may be coming to your client for the first time. Thousands and thousands of folks had this problem already in several companies. So wealth of knowledge in the form of judicial precedents is a very, very important thing. And in India and outside India, if you are able to expand it, this will develop you the jurisprudence part of it. See, ultimately, what is it we are talking about? You should have the courage, right? From where are you going to get the courage? Courage to speak about something comes from your complete understanding and confidence. That is called self-confidence. Otherwise, where will you get the courage to speak anything, to say anything, to tell anything, to write anything? Is it clear? Now, preparation, presentation, persuasion, and praying. 4 things I want to tell you. I have told you about preparation. All these things, 5P is nothing but preparation. Remember that. Now what happens is, the presentation part. Presentation is 2 types. One, physically we construct all the papers, put the numbers, 1 side paper, 2 side paper, this much of margin, that much of margin. I am not talking all those presentations. I am talking about presenting your case to the court on the day when it is moved. Presenting your case to the court when it is moved. That presentation is very important. That time, if you are thorough about it, you would have prepared 100 times prior to reaching the court hall as to what am I going to tell today. How do I initiate this? How do I impress the court within the first few minutes that there is some case here? There is something in here. Thereafter, you can always explain little late. Take some more time. That preparation requires thorough spending of time, reading of files, provisions, precedents, everything. And then, when it comes for arguments, persuasion is important. Whatever you want to say, clarity. There is no doubt without clarity, nothing is going to be heard by anybody. So clarity should be there. Second, you should be able to persuade why you are saying this. Sometimes it may involve a provision of law interpretation. Interpretation of a provision of law is very easy, I am telling you. Because one, we are all qualified professionals. We know what we are reading and understanding. Understood? Two, we are also armed with guidance notes. Three, we are also having explanations offered by various authors in the field of law where you are having some issues. So we are getting the wisdom of so many people. And we are also supported by several courts analyzing this provision, ultimately saying this is what is the interpretation. So provision of law interpretation is easier than interpreting and telling about something which is the correspondence or contractual clauses between the parties. Interpretation of a provision of law is different and much easier than interpreting the provision contained in an articles of association or a contractual matter or in a correspondence by email or whatever it is. Therefore, remember, that is very important where sequencing is there. Sequencing, which happened first and which happened next, and why, what was the trigger for somebody saying that. Therefore, dates and events of every occurrence is something which you should be ready. Basis that only you will be able to tell. Otherwise, suddenly if you say 18th August 2024, something has happened, it will not make head and tail of it. Therefore, persuasion of the court, persuading something, your interpretation must be persuasive. You should be able to add clarity, and attention of the court must be drawn every time to the various dates and events and tell this is the circumstance, this is what I thought, this is what I said, this is what they have done. So this is nothing but interpreting something which has happened. For example, a document in writing, you may not be able to deny it unless it has not been received by you, or what you received is different from what is presented by the party. So interpretation of what is the content therein is totally different from admission of the document. Remember this also. Now, at the end of the day, what you want, you should be able to tell the court. For the purpose of writing in the petition or in your paper, you would have written 17, 20 items. Court is not going to listen to you for all those things. For example, you take a petition, there will be some 20 prayers. All these are simply added there. On the day of the reckoning, you should be able to tell this is exactly what is the relief I want. Then only the court will be able to understand, yes, these are all the issues, these are all the facts, this is the provision, I can order this relief that he is asking is justified, given his requirements, provisions, and nature of, facts of the case and conduct of the party. Generally, what happens is, generally, we see people run out of patience very quickly. In this field of law, in this field of service, patience is very, very necessary. You can't be impatient about this. See, for example, today I went to the court, 2:30 is the matter. The very first case, somebody mentioned, and I am a party there. I was there and I mentioned. Thereafter, I had to wait for 222nd item, which means whole of the time I have to sit. And you will know, 4:55, my item was called. 2:30 to 4:55, I have been sitting inside a court hall. AC also was not functioning with this court time. And thereafter, our next case came up at 5:10 or 5:20 only. Then I reached the office. Patience is key to success. If you are not having the patience, you are not going to succeed in this field of law, in this field of work. Because every time you can't expect the same thing that you have in your mind to happen there. Exactly when you want to log in, your internet will go off. This is some technical problem. Exactly, you will go and stand there all the way traveling from Kolkata, say Chennai tak for this case, and the other side will come and tell, Your Lordship, my senior counsel is not well. He is on his legs in some other high court. Something he will put a card for adjournment, postpone it. What are you going to do? You cannot jump there. Your conduct is important. Your presentation is important. Your behavior is important. Therefore, you should be maintaining your cool. That is why I always say, never ever get A, perturbed, B, perplexed, C, prejudiced. Remember these three words. Never get perturbed. There is nothing is going to happen. If there is a problem, you tell the court, I will come back tomorrow. Kindly give me a date. Never get perturbed. Don't go with a prejudiced mind. Don't get perplexed if something new crops up in the scene of the court. Therefore, never get perturbed, never get prejudiced, never get perplexed. It's a very, very interesting aspect I am saying. For example, there was a case where a Section 42 application, a compounding application I filed. I am taking a very simple example, just for example. And Section 42, you know how it is drafted. Whole of the money which is received in contravention of private placement and twice of that money or 2 crores. Promoter, director. 42 is a single beautiful provision in the Companies Act. The moment somebody reads it, he will convert it into LLP and run it. Section 42 is like that. Right. So, a particular matter came and it was coming under the 1956 Act, Section 67. But 2016, NCLT has come. 2014, Companies Act 2013 has come. We have filed a compounding application. And I was arguing, the person who was listening to me was none other than former acting president of NCLT. Very thorough of me. He knows everything. Not an ordinary guy. His grasp, his interpretation, his way of connecting, you will be thrown into pieces, cut into pieces. That's the kind of judges you have. And at the end of the day, he was saying per person I will charge about 2 crores. So you have to remit 8 crores. Because that is what the provision says. So suddenly and immediately I said, Lordship, I will be considering this. There is some interpretation issue. I'll just take instructions and come. Kindly give me a short date. I escape. Otherwise, suppose you want to show that you know the provision and do it, you had it. Your client would have suffered a huge penalty. Sometimes that is what decides your success. Right time, you should be able to know where is the door. That is again a matter of art of advocacy only. It's not an ordinary thing. What normally happens is where you have to maintain silence, where you have to be patient, you forget the silence and patience are forgotten, which results in diffidence and defeat. Right place, you should be silent. You don't need to speak more than what is essential. Always crisp. Tell only that much as is necessary. Don't keep on talking. We are not giving a lecture. Second, whenever there is a difficulty, you are perplexed or a difficult situation has arisen, try to escape by placing some cards. Let me come back. Give me a day or two. I will have to engage somebody. I have to understand. I have to take instructions. So many opportunities are there. By experience, you will get it. So therefore, situations will have to be carefully understood. Why? You will be able to be present there actually, physically and mentally. We have seen so many people are physically present, mentally absent. Physically present, mentally absent. Hundreds of guys are there. They are not going to make anything. Second, if you are already well prepared, as I told you, preparation is the key to success. If you are confident, you will be courageous. It is only when you are well prepared, confident and courageous, you will be knowing what is happening around you. Your mind will have the space to listen to small things and understand it. Otherwise, when our preparation is very low or it is very less, our mind will be only on that aspect of preparation, but not on the other things that are happening around. You will not have the space to look around, see what the court is saying, how the judges are looking at you, what the other side is doing, what drama is happening. For all that also you should have the patience to see around and understand, grasp and take decisions. Therefore, preparation will alone give you that kind of opportunity that you know where is the door and when you should exit. And tactful. You would have done good service to the client. Now, I just want to tell you that there are two things which normally we tell, of course, in this, what is it called? What is there and what is not there, you should have complete idea. Your case, strengths and weaknesses, you should be very, very careful enough to note it. What is there and what is not there, where it's a very A intersection B it is. You should be able to note it. Remember this very carefully. Similarly, what you have not understood or what you could not grasp, you always apply mind again and again or consult somebody and try to understand it. Never go with some imaginary understanding of things. What is there and what is not there, you should be having no difficulty in understanding it. Second, what you have understood, what you could not understand, you should not have any difficulty in understanding it. Because everyone is not capable of understanding everything. For example, somebody may be finding it very difficult when some accounting or taxation matter is drawn. In a corporate, you will have all these things. You should be able to understand. Sometimes you may not understand the contractual terms because it will be highly technical. You should be able to understand. Sit with the client, spend hours, make inquiries, ask him to explain. Never ever miss it. For example, when I went to Hyderabad for some matter about an year back, I argued on Protection of Farmers' Rights and Plant Varieties Act. I have to study. So you must understand what you have understood and what you have not understood. It's a very interesting and important point I'm talking about. So what the other thing is, there is one saying in Tirukural in Tamil. I'll tell you what it is. It's very interesting. Tannaitan kaakin sinam kaaka kavakal tannaye kollum sinam abdinu. The translation, rough translation, I will do it. Anger is an evil thought. If you become angry, what happens is your own presentation is getting defeated. You are defeating and superimposing your anger and your behavior in a public place called court. So your own position and image will fall. And while you are angry, you may not be able to use proper words, proper and courteous words, dignified words. You will be spoiling your case. Remember this Tirukural which I have told you. Anger is going to defeat you if you are not protecting yourself from the anger. So very, very interesting. I am telling you. Very difficult for, actually we always tell it is easy to tell, but difficult to practice. But this is, we should remember every day we go to the court with an expectation that I will be able to do my justice to my client, which means I am well prepared. At the same time, in the back of the mind, I am also preparing myself. Should there be delay? Should there be adjournment motion? Should there be a difficult situation? Should there be a defeat? All these things we should know. So there are three things, remember this. A, never ever get attached. Don't think you are the client. You are only working for the client. You are doing your best. Therefore, no attachment. I am finishing now. The last sentence I am saying. Never get attached. 2, don't be under any fear. How will you overcome fear and become courageous? By preparation, confidence comes. Simple. Less than that, there is no courage. So therefore, never fear. Fear not for anything, because sometimes I have seen our fellow members having a diffidence because they are company secretaries, and they may feel that we may not do the way the lawyers will do. It's not like that. After all, you are telling your story and your provisions. Therefore, never ever fear. Number one, never get attached. Number two, never ever fear. Let not fear remove your confidence. Number three, never become angry. Three rules in art of advocacy. No attaching. You don't think you are the client. That's why I started with saying every case 50-50. This can go this side or that side. Therefore, please away. Don't give too much of confidence. I will get it. Don't worry. No, that's not the way. Because anything can happen between the journey from commencement to the consummation or conclusion. Therefore, the 5 P's which are important, I have told you. The 3 P test, I have told you. The 3 P's which you should not have. Never perturbed, never be prejudiced, never be perplexed. And the 3 rules, golden rules, never get attached, don't become the client. You are not the client. You are only working for the client. Never ever fear, never become angry. Remember these golden rules which I have told you. Totally, my whole presentation was aligned with a single letter called P. Whether it is presentation, persuasion, parties, pleadings, prayers, everything is aligned here. The purpose is to make it easy for our people to become prepared and do the job neatly. That is because you are doing justice to your client. Court is doing justice between the parties. Any questions I will answer. That's all. Thank you.
Thank you. Thank you so much, sir, for this insightful and full of knowledge session, which you gave. Our members must be, will be taking it with full support. So, sir, we have certain questions regarding this particular topic. So I will ask, and then one by one we can take these answers. So one is, what changes are expected in the art of advocacy because of proposed Advocates Amendment Bill? So that is, I mean, the upcoming amendment bills. So one question is regarding that. What are the changes, expected changes in the art of advocacy? So how it is going to affect basically?
See, to be honest, I have not gone through the amendment, whatever you said. Advocates Act amendment and all, I have not seen it.
All right.
But at the same time, art of advocacy is not going to be a matter of any provision of law or rule. At the best, there could be rules relating to procedures. So, Advocates Act may not be able to do anything with the jurisdiction clause. For example, there was a big interpretation issue whether you can render legal opinions being a company secretary, because legal opinions are exclusive preserve only of the lawyers. But the point is, if you are entitled under law to argue a case, to go and represent your client, make submissions on behalf of the client and present the case, are you not entitled naturally to issue notice relating thereto? You are there. Therefore, long back, I remember 20 years back, a notice of arbitration I issued. And Section 11 matter came up before Madras High Court. Section 11 is the provision which is invoked for appointment of arbitrator when parties are not able to identify a mutually acceptable arbitrator. So in the Section 7 court, one of the objections against me was, he is only a company secretary, and one of the very senior lawyer has argued this. How can he ever give a RFA, that is reference for arbitration under Section 21 of the Arbitration Conciliation Act 1996? The Chief Justice of India at that time, I think A.P. Shah or somebody, he said rejected it. These are all not the arguments you should know. What is the issue? Let us discuss merits. The point is, that's why I am saying never ever fear for it. Do your job in accordance. Art of advocacy is not a matter of law. It's not of rule. Rules are handmaids of justice, they are procedures.
All right, sir. Yes. The second question is, it says, during pleadings stage, can one rescue oneself citing conflict of interest, which has arisen on later on? I mean, initially there was no change, there was no conflict of interest, but during this the scenario, it changes. So, how one person can rescue one
Yes,
self?
it is possible. I will tell you two different scenarios. There was a matter where a company secretary was the person certifying various things in the company. Normal company law compliances, annual returns, board's report preparation, guidance, everything he was giving. Suddenly, the company secretary has become a lawyer. He is appearing in the same matter. It is a known conflict, but not notified by the person concerned. It was brought to the court's knowledge, and therefore he was compelled to withdraw. That scenario is scenario number one. Second scenario is occurrence subsequent has created a conflict. Any time when there is a conflict, any time, whenever it occurs, you come to know of it now only, or it happens now only. You should be able to disclose the conflict and withdraw from it. That is the height of professional ethics.
All right, sir. The moment you are getting any kind of conflict, you are supposed to inform. Yes.
Absolutely, correct.
All right. The next question we have, this is regarding AI, sir. So the question is whether AI is going to affect the art of advocacy. I mean, because so many things AI is doing for the industries as well as for the every aspect of our life. So is it going to affect the art of advocacy as well?
I can tell you an example which in one of my recent posts in LinkedIn, I have brought out the deficiencies of current AI system. You know, the question was, since I have so much of experience, I have posed a beautiful question to test the AI itself. And I was finding that they were not able to give proper answer, and they could not really relate it with the case law which is on the subject. So I had to educate the AI and then said, yes, well done, Ravichandran, great, you have done it. That's a formal way of doing it. But if you are going to simply rely on some output that is generated in the flash of a second by a tool, without your own due diligence, you are likely to be facing the wrath of the court. I still remember, I'll take this opportunity to tell you, one of the intellectual property matters in Bombay High Court, when I happened to handle it, I went through a very important judgment, IPR, trademarks matter. And that judgment refers to some other judgment, that refers to some other judgment. I took all those judgments. One particular senior advocate has presented that case law. I know the name, but I am not mentioning it. So and so quoted decision of this high court saying this. And this language, this thing is repeating in all the previous judgments also. And I searched for that case law itself, because you can't rely on somebody quoting something and therefore it is Ramaya mein kuch likha hai, therefore we can't write it. We have to read the judgment. KSR's book refers to this decision means it doesn't mean you will quote it. You have to go to the decision, read that paragraph, contextually understand and do it. And I found that judgment which they have referred did not ever contain that quote at all. So I wrote to the registrar of Bombay High Court saying that this has been one mistake somebody would have done. It keeps like Lord Denning in UK, so and so case. If you tell something, everybody will keep on writing it. So your due diligence is very important.
Even
And
if
if you are caught, apologize immediately. Immediately, you should not hesitate.
All right, sir. Even the AI is going to places, but the due diligence or human intelligence will not be defeated at any place.
Art of advocacy is different.
Yes. All right, sir. Sir, the next question we have, So two parts we have in this question. One is a company secretary who is in a corporate setup for now and getting into the practicing aspect of this. So what are the three skills which he should work upon so that he can, be comfortable before the authority. Also, the second part is a fresher PCS. If it is a practicing company secretary, then how he can also get into the, initial stage into this practicing thing.
Straight away, I'll tell you, a very senior lawyer, designated senior advocate. We always say, so and so is appearing, let us say. When he appeared in Supreme Court, he engaged another senior advocate. He is already a person of high order and reputation. But for a particular case, he felt it is necessary to appoint or engage another senior advocate. That means what? Do you think he doesn't know? It's not like that. We should be humble enough to understand, in order to give a winning case or do justice to our client, we should understand what is the height of our height. What is our height? Where do we stand and what is required? Therefore, do not project yourself. Be humble enough. Start off saying, I don't know. Clean slate theory in IBC is a big language nowadays. Clean slate theory, right? Ghanshyam Mishra. So, that is a decision name. Clean slate theory is what I say, tell to both the people, the fresher as well as the corporate secretary who is switching over to practice. Practice is a different ball game. Second, never ever on account of your perceived confidence prejudice the client's interest, because client's interest is uppermost, and if you don't know, you tell I don't know. If you need some guidance, you are not sufficiently experienced, gain experience by engaging an expert. That's all I want to say for both.
All right, sir. This
Yeah.
is this is a crucial thing for any person getting into the litigation matters, definitely.
Correct. And litigation today, let me tell you today's example. Today I was sitting in our Chennai bench. Another friend of me was there. He has traveled from all the way, he has come. He's saying, see, we have IPO matters, we have insolvency matters, we have compliance matters, we have audit matters, due diligence matters. See, if you are giving your time to whole lot of things, you will never be able to do justice. You should be able to make up your mind and travel in a particular direction, learn skills, be confident, and then add something more in the same line of thing. So if you are going to putting your whole time, dividing it into so many things and do this also is not good.
All right. Sir, the next question is, so various authorities are there, various quasi-judicial bodies are there, and courts are there. So is it that that different art is required? I mean, art and the segments are there in the arts, and which is to be opted once we are going in front of different judicial bodies or the authority. Is it the case? I mean, or it goes everywhere the same thing or different for
The
every?
same 5P which I said will apply to everybody.
All right. All right.
You
So
remember
then,
that 5P, nothing else is required.
all right, sir. All right. So we have now one more question we have. So it says because whenever we are, as you said, you mentioned it already that angry, we should not be angry at any times. It may take things from our hand. However, sir, is it a possibility to persuade in the case of if we want to express ourselves, and at times we can modulate, like
Correct.
the voice is supposed to be changed accordingly, and that
That
is
is
important for
correct.
me. All right.
See, sometimes, let us say we are friends. आपस में we are sitting, chit-chatting. I can tell you, अरे यार क्या stupidity तुम कर रहे हो? I can tell, but we can't tell in the court, no.
Okay.
Here it's a different language. Suppose, let us say, a judge is appointed and he comes and sits in a company law matter. He has never understood anything about corporate. You can't tell so what stupidity your lordship is saying, right? Can we say?
No, no, obviously.
So we should be, in my most respectful submission, I think I have a different interpretation, lordship. Kindly consider. Please see what I want to say and probably it may be correct. I just wanted your lordship to 2 minutes time. This I'm telling you how I will do it in a court of law. For example, in Supreme Court, there was a on the lighter side, to wind up, I am saying this. A very senior lawyer was posed by the judge this course. Do you think I am stupid? The judge is angry. He can be angry. Judges can be angry. There is no problem. For lawyer only you can't be.
Yes.
So he was, so he was saying, do you think I am stupid? So the senior was so very, persuasive senior. My lordship, if I have to tell the truth, I will be committing a contempt of court.
Okay, sense of humor is important. However, the voice modulation should be always be on the lighter side, not on the.
Correct. Correct.
Sir, thank you so much for this insightful webinar, and I mean, so our members must be getting a good and enriched knowledge out of your experience in this webinar. Thank you so much, sir, for giving your precious time to us, and I hope this goes on.
Thank
Thank you.
you. Thank you. And I apologize for this delay because of unavoidable circumstances.
No problem, sir. Thank you. Thank you so much, sir. Thank you.